Thank you so much, Professor, for that wonderful introduction, and it is truly an honor to be back here at the Law Center. As Professor O'Sullivan noted, I'm not only an alum of the Law Center, I'm in fact an alum of this very building. This is where I stayed as a first year. Lots of long evenings here studying as a first year. Much has changed. Much has changed. There was no international law building here when I was a student. There was no Ginsburg Fitness Center. There were lots of parking lots around here that are now occupied by skyscrapers. And in fact, there was no courtyard here. That courtyard used to be F Street. It used to run right through the courtyard that now has formed such a tremendous campus for our students. But despite all of those changes, the ethos of this school has not changed. It has always been a world-class legal institution providing a world-class legal education to individuals hailing from diverse perspectives and backgrounds and careers. The Law Center accurately describes itself, in my opinion, as the place where theory meets practice and where we learn the practice of law where laws are made. As the professor noted, before coming up here to GWERTS, we had an opportunity to meet with a number of her students, and I am so proud to say that the best traditions of this great institution are continued to be carried forward by these students, and I look forward to getting to know more of them, and I look forward to seeing what they each bring to our great profession and to our world. Just as unwavering as the values of this great institution are the values of another great institution, the Department of Justice. Our values of public service, our commitment to our incredible colleagues, our commitment to the pursuit of justice. And that is why, at the outset of my comments this afternoon, I just want to acknowledge the hard work and dedication of the many public servants across the criminal division who had an incredibly productive 2022. 2023 will be even more productive. And it has ensured that the division remains a national leader in corporate enforcement. Many of our prosecutors, our public servants, are with us here today for this event. They include my principal deputy assistant, Nicole Argentieri, two of my deputy assistant attorney general, Lisa Miller and Kevin Driscoll, two of my senior counsels, Keith Edelman and Dahoud Askar, Glenn Leon and Lorinda Laye, the chief and principal deputy chief of the fraud section. Brent Weibel and Molly Moser are here, the chief and principal deputy chief of the money laundering and asset recovery section. But beyond our current public servants that are in the halls of the division today, we are joined by so many alums of the division. People like Brian Rabbit, Joe Beamsterboer, Deb Connor. And I also want to give a special shout out to Matt Miner, who was also an alum of our division, and I also served as a law partner of Matt during our time in private practice. Like myself, a former chief compliance officer, Matt now serves in that role for a significant Fortune 500 company in our country. I also want to give a special shout out to a number of our criminal division members and who happen to be Law Center alums themselves. I already mentioned Lorinda, Andrew Ginton, and David Last among them. Now, many of you, both alums as well as current members of our division, have made considerable contributions to the fight against corporate criminality. These are offenses that undermine the integrity of our financial institutions and our markets. They threaten our public safety and national security. and they wrongfully divert money into the pockets of criminal actors. Be clear, we are using every tool at our disposal to combat corporate criminality, including more sophisticated data analytics and other means to proactively help us identify criminal conduct. Our prosecutors, our analysts, our agents are bringing to bear an increased array of experiences and expertise. And just as importantly, we are working more closely than ever with our law enforcement partners from across the globe. The vast majority of our FCPA resolutions over the past few years, in fact, are the result of cooperation and coordination with foreign and domestic authorities. This past year alone, our fraud section secured convictions of over 250 individuals, including more than 50 convicted at trial. They entered into 7 criminal resolutions with corporations, and they announced 2 corporate enforcement policy declinations. Our money laundering and asset recovery section was just as productive, convicting more than 24 individuals and obtaining 2 corporate guilty pleas, including a guilty plea from a financial institution that agreed to forfeit $2 billion in connection with one of the largest international financial scandals in history. That was our 2022. There will be more in 2023. And so while we continue to utilize our investigative resources and our partners to uncover wrongdoing, we could never completely identify and address this area of criminality without corporations, without our corporate citizens coming forward and reporting the conduct of these wrongdoers. That is what motivated the Criminal Division back in April 2016. Many of the individuals I referenced earlier walked the halls of the division when that policy was first implemented in 2016. When we first announced a voluntary self-disclosure incentive program, our FCPA pilot program, to be as transparent as possible. At that time, we laid out a roadmap for what companies could expect if they chose to self-disclose misconduct and fully cooperate with our investigation and timely remediate the wrongdoing. In November of 2017, we expanded that program to become the FCPA corporate enforcement policy, which we subsequently incorporated into the department's justice manual. And since at least 2018, we have applied this policy to all corporate cases prosecuted by the division. Our existing policy, and many of you know this, our existing policy provides that if a company voluntarily self-discloses, fully cooperates, and timely and appropriately remediates, there is a presumption that we will decline to prosecute absent certain aggravating circumstances involving the seriousness of the offense or the nature of the offender. These aggravating circumstances include, but are not limited to, involvement by executive management of the company in the misconduct, a significant profit to the company from the wrongdoing, egregiousness or pervasiveness of the misconduct within the company, or criminal recidivism. Now, our existing policy also offers the potential benefit of a presumption of a declination to companies that uncover during the M&A due diligence process misconduct by subsidiaries or other entities that they are seeking to acquire, and then self-report that misconduct to the criminal division. And if a company self-discloses, but a criminal resolution, a guilty plea, an MPA, a DPA is warranted, our existing policy offers 50% off the low end of the applicable sentencing guidelines penalty range. This is the current policy. That policy has demonstrated the department's commitment to rewarding companies that do the right thing when learning about possible misconduct. And the examples are evident. Just last month, for example, we announced that we declined to prosecute a French aerospace company, Safran SA, after it disclosed FCPA violations that it uncovered during post-acquisition due diligence. The bribe payments to a Chinese consultant that the company uncovered occurred between 1999 and 2015, but the company nonetheless made a full self-disclosure. The company fully cooperated. It ensured that the remediation was complete, and it agreed to disgorge the ill-gotten gains of its U.S. subsidiary, doing the right thing. Another example, our corporate resolutions with ABB entity, again in December of 2022, illustrate how the CEP applies to companies that fully cooperate and remediate even if they don't make a voluntary self-disclosure. You see, ABB had entered into FCPA resolutions with the department in 2014 and 2010, and in the wake of its prior misconduct, ABB made an investment. It implemented a compliance program that detected the FCPA misconduct in South Africa. And the company planned to promptly self-disclose it. It had even scheduled a meeting with the government to do so. But before that meeting occurred, a media report drew attention to the possible wrongdoing. But because the company could demonstrate intent and efforts to self-disclose prior to that, and without any knowledge of the media report, our prosecutors weighed both the early detection and the intent to disclose in ABB's favor. That company also demonstrated its extensive remediation, its extensive cooperation. And so despite its recidivist history, and despite the department's policy disfavoring successive deferred prosecution agreements, the parent company was still able to avoid a guilty plea. It entered into a DPA with 2 subsidiaries entering guilty pleas. Again, ABB was a recidivist. It had a recidivist history. And so we did not give the company the benefit of a reduction from the low end of the guidelines range. Instead, to account for the recidivism, the reduction was from the midpoint between the middle and the low end. So when a company has uncovered criminal misconduct in its operations, again, I say the clearest path to avoiding a guilty plea or an indictment is voluntary self-disclosure. It is also the clearest path to the greatest incentives that we offer, such as a declination with disgorgement of profits. And a functioning compliance program with effective detection mechanisms best positions companies to not only identify misconduct in the first place, but to make the important decision of whether to disclose it. Now, I've been in private practice, like many of you. Like some of you, I've also walked the halls of corporate America. And so I fully understand the significance of a company's decision to voluntarily self-disclose and to fully cooperate, as well as the consequences that that kind of a decision can bring. These are indeed complex discussions in boardrooms. And each company and each outside counsel should, of course, choose to do what is in the best interest of the company. But be clear, this policy, in providing transparency to the potential incentives, we are also underscoring that a corporation that falls short of our expectations does so at its risk. Make no mistake about it, failing to self-report, failing to fully cooperate, failing to remediate can lead to dire consequences. To that end, I give you Exhibit A, the Balfour Beatty Community's military housing fraud guilty plea from last year. There was no voluntary self-disclosure. The company's cooperation was lackluster at best, merely the bare bottom minimum for credit under the guidelines and a reduction for acceptance of responsibility. It also failed to conduct appropriate remediation in a timely manner, and therefore the company did not get any additional reduction of the fine amount under our corporate enforcement policy. In fact, we determined that the starting point for the fine amount should be between the low end and the midpoint. And moreover, this was a company that had no recidivism. This was not a recidivist company, and yet we still determined that a guilty plea was appropriate due to the seriousness and the pervasiveness of the conduct at multiple bases across multiple military branches. And finally, the company's compliance program was so inadequate, not only at the time of the misconduct, but at the time of the resolution, that we imposed an independent compliance monitor. This example illustrates that the default is not a declination. No, it's not an NPA. It is not a DPA. We have secured 6 parent-level corporate guilty pleas during my tenure in cases involving a range of conduct, from foreign bribery and bank fraud to emissions testing and spoofing. It is a nuanced, but it is a tough approach that we will continue to follow in each and every case. And companies are not presumed to qualify for a declination. No, they must earn it by following our policy. Now, as many of you know, in September of last year, our Deputy Attorney General asked all department components to write voluntary self-disclosure policies to the extent that they did not already have them in place. And the purpose was to clarify the benefits of promptly coming forward to self-report so that chief compliance officers and general counsels and others can make the case in those boardrooms that voluntary self-disclosure is a good business decision, quote, unquote. From the very top of the leadership of the department, voluntary self-disclosure is being recognized and lifted up as a virtue. So although the division already had that kind of a policy in place, we took the DAG's call as an opportunity to reassess and strengthen our own policy. Which brings us to today, where I am proud to announce the first significant changes to the Criminal Division's corporate enforcement policy since 2017. As you will hear shortly, these changes offer companies new and significant and concrete incentives to self-disclose misconduct. And even in situations where companies do not self-disclose, our new policy provides incentives for those companies as well to go far above and beyond the bare minimum when they cooperate with our investigations. Again, I am proud to share with you these announcements, these important revisions, which will apply to all corporate criminal matters handled by the division, including all FCPA cases nationwide. These revisions provide specific additional incentives to companies for voluntary self-disclosures, as well as for cooperation and remediation. The revisions make clear that we will be facing very different outcomes for companies that do not self-disclose, that do not meaningfully cooperate, that do not meaningfully remediate. So I submit to you, recognizing the many challenges that come with the decision to self-disclose. Oftentimes, outside counsel and corporations recognize that an aggravating factor under our current policy may prevent a company from obtaining a declination, and that concern may have led companies and their outside counsel to conclude under our prior version that it is more prudent not to disclose the misconduct. I submit to you that the revised CEP presents another path, a different path for companies facing such a choice, a path that incentivizes even more robust compliance on the front end to prevent misconduct and requires even more robust cooperation and remediation on the back end if a crime occurs. Namely, even if aggravating circumstances are present, although a company will not qualify for a presumption of a declination, under the revised CEP that I am announcing today, our prosecutors may nonetheless determine that a declination is the appropriate outcome if your company can demonstrate that it has met each of the following three factors. First, that the voluntary self-disclosure was made immediately upon the company becoming aware of the allegation of misconduct. Second, at the time of the misconduct and at the time of the disclosure, the company had an effective compliance program and system of internal accounting controls that enabled the identification of the misconduct and led to the company's voluntary self-disclosure. And then third, the company provided extraordinary cooperation with the department's investigation and undertook extraordinary remediation. Each of these factors, I suspect, is familiar, feels familiar to us. That is by design. We are requiring companies seeking the possibility of a declination, even in the face of aggravating factors, to take extraordinary measures before, during, and after a criminal division investigation to earn that type of an outcome. You see, this possibility, this incentive is directed squarely at companies that take compliance and good corporate citizenship seriously. Now, while some companies may be able to overcome their aggravating factors and may be able to receive a declination with disgorgement by meeting those criteria, I recognize that others will not. But the revised CEP I'm announcing today contains incentives for those companies in that situation as well. You see, if a company voluntarily self-discloses misconduct, fully cooperates, and timely remediates, but we know that a criminal resolution is warranted, our division prosecutors will now accord or recommend to a sentencing court at least 50% and up to 75% off of the low end of the U.S. sentencing guidelines range, except in the case of a criminal recidivist. And in that case, the reduction will generally not be from the low end of the fine range, and in all cases, our prosecutors will have discretion to determine the starting point of that guidelines range. This revision represents a significant increase from the previous potential maximum reduction of 50% off of the guidelines range. And in these circumstances, we will generally not require a corporate guilty plea, including for criminal recidivists, absent multiple or particularly egregious aggravating circumstances. So while it is relevant and while it is important, criminal recidivism alone will not always mean a guilty plea. Again, this policy applies to all criminal division corporate resolutions, not only voluntary self-disclosure cases. As we all know, there will be many instances, there have been many instances in which a company will not have voluntarily self-disclosed conduct to the division. In those circumstances, the revised CEP provides our prosecutors with a greater range of options to distinguish among companies that commit crime. The revised policy provides incentives for companies that do not voluntarily self-disclose, but still fully cooperate and still appropriately remediate. In those cases, the division will recommend up to a 50% reduction off of the low end of the guidelines fine range. That is twice the maximum reduction available under our prior version. And in the case of a criminal recidivist, the reduction will most likely not be off of the low end, and again, our prosecutors will have the discretion to determine the starting point. But to be sure, while 50% off of the low end of the guidelines is a maximum available, absent of voluntary self-disclosure under the revised CEP, I can't say this strong enough. Each and every company starts at 0 cooperation credit. Let me say that again. Each and every company starts at 0 cooperation credit and must earn credit based on the parameters and the factors outlined in the CEP. This is not a race to the bottom. A reduction of 50% will not be the new norm. It will be reserved for companies that truly distinguish themselves and demonstrate extraordinary cooperation and remediation. But you see, having a greater range of cooperation and remediation credit available, from 0 to 50 instead of from 0 to 25, and using the full spectrum of the guidelines ranges from which to apply those reductions, will allow our prosecutors to draw greater distinctions, finer distinctions among the quality of a company's cooperation and remediation. That's a lot. That's a lot. I'm going to pause here for a moment because I suspect many of you may be curious as to how our prosecutors will distinguish between extraordinary and full cooperation under this revised policy. We are all aware of the differences between corporations and individuals, of course, but with respect to how we consider cooperation, the lens and the framework through which we analyze the level and degree of cooperation, it's not all that different, folks. See, I'll note for you a few concepts: the immediacy, the consistency, the degree, the impact of the cooperation that apply to cooperation by both individuals and corporations, which will help to inform our approach in assessing what we determine to be extraordinary. To defense counsel with us here in the audience today, I ask you to hearken back to your days as a prosecutor. You know that when you were a prosecutor, what you valued in assessing the quality of a cooperator's assistance. You valued when an individual began to cooperate immediately and consistently told the truth. You valued when individuals would allow us to obtain evidence we otherwise couldn't get, like quickly obtaining and imaging their electronic devices or having recorded conversations. You valued when cooperation produced results, like testifying at trial or providing information that led to additional convictions. These are just a few examples, but in many ways we know that extraordinary cooperation and full cooperation are perhaps different in degree and not so much in kind. And so to receive credit for extraordinary cooperation, companies must go above, they must go beyond the criteria for full cooperation as set forth in our policies, not just the run-of-the-mill or even gold standard cooperation, but truly extraordinary. At the same time, be clear, the government will not affirmatively direct a company's internal investigation if the company in fact chooses to do one, and companies are often well positioned to know the steps that it can take to best cooperate in a particular case. Of course, the facts and circumstances of each case will be unique. But be clear, this revised policy is sending an undeniable message to the public. Come forward. Cooperate. Remediate. We are going to be closely examining how companies discipline bad actors and reward good actors. You have heard it from our Deputy Attorney General. You have heard it from our Attorney General. You have heard it from me. Our number one goal in this area is individual accountability. And we can hold accountable those who are criminally culpable, no matter their seniority, no matter their name, no matter their title, when companies come forward and cooperate with our investigations. Failing to take those steps, and again, a company runs the risk of increasing its criminal exposure and monetary penalties. I've already given you Exhibit A in the Balfour Beatty Communities case, but I give you Exhibit B, the Bank of Nova Scotia spoofing case, and I give you Exhibit C, the Glencore benchmark manipulations resolutions, where we determined that the appropriate starting point for a guidelines reduction would be above the low end. In Glencore, the company only received a minimal reduction for cooperation and remediation under the CEP because of late and because of incomplete cooperation and failure to take adequate, timely disciplinary measures with respect to certain personnel involved in or aware of the criminal misconduct, which itself was pervasive. And in Bank of Nova Scotia, we determined that a fine at the very top of the applicable guidelines range was appropriate because instead of remediating the misconduct, the compliance program, the compliance function actually contributed to the misconduct itself. That is our message for today. To all assembled, but especially to our students. I started out at the beginning noting some of the changes since I was last on campus. But there is, unfortunately, one constant. As a member of this community, none of us are sheltered from criminality, particularly violent crime. We need only look outside of this window or walk one block away to experience in stark terms the despair and the hopelessness of crime and its root causes right here in this neighborhood. The answer, the long-term answer, is not to run away from it, but to use students, to use your resources, and to use your education, and use your experiences to increase your civic engagement and help reach truly lasting solutions to these social ills, to our corporate citizens. The message is very much the same. You see, our job is not just to prosecute crime, but to deter and prevent crime in the first place. Through our enforcement efforts and our policies, we are committed to incentivizing companies to detect and prevent crime in their own operations, and then to come forward and cooperate with us when they identify criminal wrongdoing. We need corporations as our allies in the fight against crime. And we believe that our revised policies will, at the end of the day, further our ability to bring individual wrongdoers, the corporate executives, the employees, the rogue agents who engage in misconduct, to bring them to justice. Your resources, particularly your investment in your compliance functions, can help increase your corporate civic engagement and lead to lasting solutions to corporate criminality. That is my call to you today. I thank you all for joining us here today, and have a blessed afternoon. Thank you.